In this short video, the supervisor Sue has called Rob into a conference room.
At a big company meeting where Sue announced a major decision, Rob spoke up and told everyone that he thought Sue's decision was the wrong one. As Rob's boss, Sue arranged this meeting to discuss a situation with Rob. This video shows two possible approaches Sue can take to resolving a conflict. Which would you choose?
Hi Sue, how are you?
I am fine, Rob. I hope you are as well.
You asked to see me. What is this about?
Well, I was very disappointed in your response to the announcement yesterday. I think it was unprofessional and put me in a very bad position as your supervisor.
I am sorry to hear that, but if you knew what you were doing, I would not have responded that way.
Rob, I have had enough of your childish behavior and lack of respect. You can pack up your belongings now. I will have security escort you from the building. Goodbye. Well, Rob, I am sorry that you feel that way. Had I known you felt that way, I would have made sure we sat down to discuss this prior to the meeting. Now, why don't we sit down and discuss why you think I do not know what I'm doing?
Rob and Sue sit down, on the same side of the table, facing each other, both leaning slightly forward in an active listening pose. This conflict has a chance at being resolved.
As for introduction, domestic inquiry in the term of human resource management can be defined as the quest on any incident, elements or truth that related to the charges alleged by the employer against its employee. It is an investigation that created by the management itself as the management against its own employee who are reportedly committed certain acts of misconduct behavior in the company. The inquiry usually will be conducted before taking any disciplinary action against the employee for the misconduct. The objectivity of the inquiry is fully guaranteed and it is clearly can be seen in the way when the accused employee is fully allowed and be given an opportunity to deny the charges and show or tell his story, including the evidence to support his argument. It is also stated that the accused employee need to be accompanied by his union or committee representative, if any, and whenever applicable at the inquiry. In addition, the whole process of inquiry is also will be recorded as it is because if any important information is being overlooked, the responsible party could be just refer back to the recorded version. The inquiry would also consist the rule of natural justice, as this basic concept has two components, which is the first one is the rule of fairness and the second one is the rule against bias. Moreover, unfortunately, since it is entirely just an effort on searching the truth, it is necessary to note that the whole process of the domestic inquiry does not proceed on any judgment or set up any punishment to the accused employee. But if the inquiry proves that the employee has committed misconduct, there are still possible actions such as downgrade or dismiss without notice the employee that could be taken by the employer itself.
Hi, Assalamualaikum. My name is Nurul Syafiqah binti Abdul Aziz. Today I will present about the importance of domestic inquiry. Firstly, as a general rule, no employee should be fired for misconduct unless they have been given the chance to defend themselves or be heard. As a result, a domestic investigation is critical because it gives the employee a chance to defend themselves. That is to say, an employee accused of misconduct should be allowed to be heard and defend themselves. The opportunity for employees to defend themselves after the committing misconduct should give in full and sufficient time to complete the defense against themselves. It is to prove that an allegation of misconduct against an employee is carried out fairly and only those who are guilty are punished. Not only that, employers can convene a domestic inquiry to let employees properly defend themselves, which will aid them in the determining whether the misconduct has been accurate and what type of punishment should be applied. For example, no employee should be fired for a misconduct unless he or she has been given a chance to defend themselves or be heard. In addition, in the Corporate Relations Act 1967 or the Employment Act 1955, the law does not provide a specific definition of misconduct has been explored in depth by various cases in the industrial court. It occurs when an employee's conduct of action is commonly deemed to be detrimental to his employer's reputation or interest. Furthermore, because the employees bear the burden of showing that the dismissal was justified, employers must have their facts straight before making a decision based on the hearsay evidence or mere suspicion. If they make a hurried choice, the employer will come to regret it if their decision is scrutinized by the industrial court. Then, before the employer make a final decision as a result of a disciplinary violation that will be lead to suspension and dismissal, even if the employee commits an offense, it is very important for the employers to allow the employee to defend themselves and voice the problem, such as when an employee is absent for 3 days without any notice. The employee may defend himself during the internal investigation process for the employee to inform the real matter before his dismissal.
I would add a few more points, which is to give chance to the employee to defend themselves to make sure that the employee is fairly treated. It is because using domestic inquiry, it will disclose whether or not the individual commit the misconduct on jobs. Misconduct refers to an employee's inappropriate behavior in the workplace. When a company sends their employee to training, some of wrongdoing can be resolved. Harassment and discrimination are examples of private usage of business contacts. Domestic inquiries are credible proof that an employer has taken the required procedure to guarantee that an employee is treated fairly if alleged wrongdoing is reported, aside from being a legal requirement. If an employee sue their company for unjust or unfair dismissal, a judge would almost certainly look to the domestic investigation for proof that the employer's actions were reasonable and appropriate. According to Employment Acts of 1955, before an employer can impose a punishment, the employer must conduct an investigation into the wrongdoing of an employee. This is a legal requirement put on the employer. Not only that, according to Malaysian rules of natural justice, no one shall be condemned without being heard. In the context of domestic inquiry, this means that the employee must have a reasonable opportunity to be heard in their defense, such as where the judge should listen to both sides and include the opportunity to face and defend themselves.
The second importance of domestic inquiry is to demonstrate that the employer has taken the appropriate procedures to guarantee that workers are handled fairly in the case of claim of wrongdoing. Misconduct in this term refers to undesirable or improper behavior, particularly by an employee or the professional. To be more specific, when an employee is suspected of stealing business funds or misusing company for personal gain, there is no set of protocol for an inquiry, but as a general rule, the employee should be informed their suspected misbehavior. The employee should be given the chance to state their case, and the person conducting the inquiry should not be in a position that may indicate bias. So we can see that misbehavior in the organization may occasionally produce significant issues. If the employer can manage this problem successfully, he can also provide the final service to his clients and get more profit from it. That's all from me. Thank you.
In a conclusion, domestic inquiry is very important to defend the rights of an employee so that they are given fair and equitable treatment. In addition, it also investigates whether the employer has taken the appropriate steps after reporting cases of misconduct by employees. Basically, usually the employer has his own lawyer and takes whatever action according to his legal advice, while the employee usually acts on his own without seeking advice from any party experienced in the law and disciplinary process. It should be emphasized that employers also cannot arbitrarily impose punishment or dismiss because they must conduct a due inquiry and they need solid evidence before punishment can be imposed. Is it a mistake for employees to assume that if they just confess and apologize, the employer will forgive and everything is back to normal? Even employees who are actually innocent choose the apologize option only and appeal, and this is the wrong tactic. That's all from us. Thank you for your attention.